Today's presentation is about a Court of Appeal decision which was given on the 15th of December 2016. The name of the case is Visiak and D&R Constructions Australia Proprietary Limited, 2016 NSWCA 353 is the citation.
So Tom, you appeared for the successful appellant in the Court of Appeal. Can you explain the facts pre-litigation?
Yes, of course. It was a simple building contract. It arose out of a building contract for the building of a dwelling. The building contract was entered into in December 2011, and work started in the construction of the building, and progress claims were submitted in the course of the contract. And then on the 4th of June 2013, what purported to be a progress claim was submitted. In fact, it was just an invoice. And the owners, the people for whom the dwelling was being constructed, didn't want to pay it. They were reluctant to pay it. They didn't think that the work that was said to have been completed was completed. They were generally worried about the cash position of the job. And then they wrote to the builder to say so, and the builder, believing quite sincerely that it had an entitlement to under the contract, suspended the works.
It's now not actually in dispute, though, that the respondent builder was in fact not entitled to be paid that claim.
No.
The claim made in June.
No, that was the subject of the principal dispute in front of the tribunal at first instance, which was that progress payment claim payable. And it was determined, and this was never challenged after the tribunal's finding, that it wasn't payable for two principal reasons. Firstly, the contract, as most contracts are, was quite specific about the form the progress payment claim should take. It was required to say how much work had been done, how much had been paid, and the balance and amounts for GST and so forth. The contract was quite prescriptive. It was a standard form contract, and it was quite prescriptive. And what was in fact sent was simply an invoice. And the second thing that was wrong with it, or was eventually found to be wrong with it, was that it claimed payment for the completion of various items, tiling and painting and the installation of some stairs, and they hadn't in fact been completed. They'd been partly completed, but they hadn't been completed. And although the contract wasn't expressed in terms of completion, it was necessarily implicit that the works had to be completed, or at least substantially completed, because if you think about it, if that wasn't the case, the builder could simply send out one progress claim right at the outset.
Yes, you can't invoice for works you haven't actually yet done.
You can't invoice for works you haven't done. It's contrary to the principle of a progress payment claim. So in any event, the progress claim payment was sent, it wasn't paid, and the builder stopped work, and purported to suspend works under the contract because there was a provision, as there usually is in contracts like this, saying that if a progress payment claim hasn't been paid, there's an entitlement to suspension. And the parties brought in lawyers and had negotiations. And eventually on the 17th of September 2013, after a lot of correspondence trying to resolve the issue, the owner's solicitor wrote a letter saying, look, we're going to have to make alternative arrangements to bring in other builders to complete the works, and it's our intention to terminate the contract if this matter can't be resolved. Please let us have your response.
And it's not uncommon in these types of matters to send the sort of abundance of caution, here's your breach, we intend to terminate, type letter.
It was interesting. One of although the contract doesn't break any, the appeal decision doesn't break any specific legal ground, it doesn't set a major precedent in the law really, it is quite instructive, because the correspondence between the solicitors, which was carefully written, was what it was all about. And it might be usefully read by practitioners who are faced with owners or builders in the same situation as a lesson on what to do and what not to do. In any event, after there was some further correspondence, and eventually the builder solicitor terminated the contract, and it did so on two bases. The first basis was that the owner hadn't paid the claim. The second basis was that by writing the letter saying that it intended to bring in new solicitors to complete the works, the owner had repudiated the contract which the builder purported to accept. So that was the issue. There were mutual allegations of termination. The owner said that you, the builder, have effectively repudiated the contract by unlawfully suspending works and eventually wrongfully terminating the contract. The builder said the owner had repudiated the contract by not paying him and then threatening to bring in other builders to complete the works. So that was the factual background to the litigation. The matter then went to the tribunal.
So if we can just turn now to the terms of the contract, which being a standard form home building contract,
yes,
is a fairly wide application.
Yes, it was a standard form. Clause 20 dealt with payment, and it required the contract price to be paid in accordance with the schedule. The progress payment claim was to show the value of the contract work performed at the date of the claim, brief description of any variations, any other adjustments, the amount previously paid by the owner other than a deposit, the amount claimed being the difference between the work carried out and variations and the amount paid, and it also had to show the proper GST charges. Then clause 21 dealt with suspension of work and gave an express right of suspension if the owner failed to pay or cause to be paid any payment, a progress payment claim. And then there was a provision for determination of the contract in accordance with its terms. They were all standard provisions which are commonly to be found in home building contracts.
So obviously the correspondence between the respective solicitors wasn't able to settle the matter, and it proceeded to NCAT?
That's right. One of the things that lessons to be learned from this litigation is one of the things that the builder's solicitor did in the course of the correspondence was to introduce additional terms into the contract, as it were. In other words, it said that the builder would only come back to site to carry out works if certain things were done or agreed to which weren't stipulated in the original contract.
Well, one would have thought the contract would govern the rights of the respective parties.
Well, one can see why they did it. They were trying. The solicitors made a bona fide attempt to negotiate a resolution to the impasse they found themselves in, but that was the subject of comment in the Court of Appeal judgment. But you're right. Yes, things eventually reached an impasse. The contract was terminated by the builder, and all the parties went off to the tribunal. So what the tribunal at first instance found, after 2 days of hearing, was that the progress payment claim wasn't payable because it wasn't a progress payment claim, and the works for which a claim was made hadn't been completed, from which it followed that the builder's purported suspension and termination were unlawful, from which it followed that the builder's additional costs of completion, that is over and above what they would have had to pay the builder anyway, were payable to the owners by way of damages.
And that's for essentially the costs of another builder to come in and complete the works
That's right.
outstanding under the contract. And so on what grounds did the builder appeal to the appeal panel?
The grounds of appeal was that, the argument was that the tribunal at first instance hadn't dealt with the builder's argument, which was that the letter from the owner's solicitor saying we're proposing to terminate the contract and get our own builders to complete the works was repudiatory, and that they were entitled to accept that repudiation. And that argument was successful in the appeal panel. The broad argument against it that I made was that that was a wrong characterisation of the letter. I said that the owners they did have the right to terminate the contract. The builder had suspended the contract and was not lawfully entitled to. Therefore, they were simply saying what they were entitled to do.
They're simply giving notice of their intention.
Saying what they proposed to do and giving notice of what they proposed to do, so that to give the builder one last chance to come to the table and negotiate a resolution. But that was not how the panel saw it. The panel considered the letter to be repudiatory, and it followed, therefore, that the termination of the contract after that letter took effect as acceptance of a repudiation. And in those circumstances, the owner was entitled to, the builder, was entitled to damages, being the amount which represented the work it had carried out, less the amount it was paid, plus any loss of profits on the remainder of the works.
And that's perhaps a slightly surprising finding, given that those sorts of letters are often sent for an abundance of caution. Specifically, you're in breach, we're entitled to terminate, we intend to exercise this pending you speaking to us in the next 24 hours.
Well, I thought it was a surprising finding, but on the other hand, I wouldn't I? Because I was arguing the matter, but that was what was argued against me, and so at that stage we were down in the litigation, as it were. Now the challenge we then faced was to identify a question of law, because to appeal from the appeal panel, you have to rely upon the right of an appeal from the appeal panel is governed by Section 83 of the Civil and Administrative Tribunal Act 2013. It's a statutory right, and it's only on a question of law. And that presented challenges, because what constitutes repudiatory conduct is factual.
Yes, and under Section 83, even on a question of law, still requires leave.
It still requires leave, that's absolutely right. So our argument in relation to leave was twofold. The first thing we said was that this is a situation that arises very frequently, that a builder stops work because it hasn't been paid, and so it raises if not a specific legal issue of general importance, a factual scenario of general application. And third, we said there's an injustice being done here. The injustice is that the parties were trying to bona fide resolve a dispute. The builder had been shown to be in the wrong, because it's unlawfully suspended work, and there was no allegation after the original finding that the original finding was wrong, and the owners were put in what was termed an invidious position. They could either pay when they had no entitlement to.
No obligation to, given that...
Sorry, no obligation to, that's absolutely right. For work that hadn't in fact been carried out, or they could bring in new builders. They'd have to. They couldn't be in the situation where they were they didn't pay, but they couldn't do anything about it and were stuck in perpetuity, not bringing new builders on site to complete the works.
It does seem a very unfair situation in that they've received an invoice for work that hasn't actually been done, and under the appeal panel's reasoning, the builder can simply say, well,
yes, as soon as
you have to pay me a large amount more before I do anything.
Well, I think it's more that as soon as the owners took practical steps to say that they were going to bring in new builders to complete the works, they were found to have repudiated the contract. So they were in that difficult position.
And that's something they're entitled to do anyway under that contract.
Yes.
If there's been, they can then recover the costs of the works by the new builders.
Yes. So anyway, we went to the Court of Appeal. The decision, I should say, was the decision of Justice McDougall's, who was sitting in the Court of Appeal, to which Justices, or President Beazley and Her Honour Justice Simpson agreed. But the first thing that was pointed out was that there's no universal, I think the word used was universally applicable bright line distinction between questions of fact and questions of law. After a discussion of the authorities, His Honour summarised the authorities as such. An ultimate finding of fact, such as a finding that there's been a repudiation of a contract, can only be vitiated by error of law if, first, there is no evidence to support that finding, or secondly, the finding was not reasonably open on the whole of the evidence. And importantly, reasonably in this usage denotes rationally rather than something on which minds may reasonably differ. Humans are not, of course, always. You can appear to be reasonable without being rational.
Indeed.
Because I think that's that expression, human beings are not rational, but they're rationalising. They like to think that their decisions are rational. So what His Honour then went on to do was to focus on the context of the 17th of September letter, because it shouldn't be looked at. It was acknowledged that it shouldn't be looked at in isolation. It should be looked at in light of all the background circumstances. And he considered what those background circumstances were, and then he went on to look at whether or not the decision that it was repudiatory was rationally open. Now, but before he did that, there was a brief discussion, which isn't part of the ratio of the case, on the powers of the Court of Appeal when there's an appeal, or of a court, I should say, when there's an appeal on a question of law alone. Section 83 itself, a party to an external or internal appeal may, with leave of the Supreme Court, appeal on a question of law. The court hearing the appeal may make such orders as it considers appropriate in light of its decision on the appeal, including but not limited to the following: an order affirming, varying or setting aside the decision of the tribunal, or an order remitting the case to the tribunal, the case to be heard and decided again by the tribunal, in accordance with the directions of the court.
Well, it's quite broad language of 83 sub 3, may make such orders as it considers appropriate in light of its decision.
Yes, that's right. But in a case called B&L Linings Proprietary Limited in the Chief Commissioner of State Revenue, which is reported at 2008-74 New South Wales Law Reports 481, President also said, in considering the the relevantly similar legislation, even if an error of law were demonstrated, a court has no authority to engage in fact-finding on the merits of the case. So it's not like an appeal by way of rehearing.
No, it's not a de novo hearing.
More like an appeal by way of judicial review. In the same case, Justice Baston said that the course of authority favoured the proposition that in appeals like this, the powers of the court are to make such orders disposing of the proceedings before the tribunal as unnecessary, based on the findings of fact made and inferences drawn by the tribunal, and where no other conclusion is open, and in limited circumstances to make other appropriate orders, including orders exercising discretionary powers.
So it's not the case that once you get through on the question of law, you can then perhaps re-agitate some of the disputed factual issues.
I think the position is you can't re-agitate or you can't make further findings of fact. You probably can't revisit findings of fact. But findings can be made as unnecessary based on findings of fact and inferences drawn by the tribunal. Now, there may or there may not be some, as His Honour Justice McDougall observed, difference between Justice Baston and President Alsop, but that wasn't the subject of any further discussion because it didn't arise on this appeal. In any event, His Honour went on to consider the tests for repudiation, which are not, or renunciation, which are not the subject of dispute and are established. He said that after having looked at the factual circumstances, the circumstances in which the letter dated 17th of September 2013 was written included the fact that the builder had suspended work because the owners had not paid, the fact that the builder was not entitled to insist on payment for the two reasons we've originally discussed, the fact that the builder had no justification in suspending work, the fact that the builder's suspension of work put the owners in an invidious position, the fact that if the owners could not negotiate a resolution, they had no choice but to have the works completed by somebody else. The fact that the builder's stated position was that it could only resume and complete the works if the contract was varied, and that was what we discussed earlier in the correspondence. And the fact that the owners had indicated a willingness to consider the variation sought by the builder and invited the continuance of negotiations. And what His Honour found effectively was that the panel had not taken into consideration the background that the builder had wrongfully suspended the works because of a claim for payment which was not lawful, and also had stipulated that it would only return to works on subject to additional conditions. So, having said that, some important considerations appeared not to have been taken into account, His Honour then went on to consider whether the decision, based on the 17th of September 2013 letter, was repudiatory, was reasonably, in the sense of rationally, open to the panel. And in short, he said it wasn't. What His Honour Justice McDougall said, in his view, that when the letter was analysed by reference to all the relevant factual circumstances, it could not, in law, amount to or evidence a repudiation. What they were saying was the owners will terminate because of the unlawful suspension of the works unless the builder resumes negotiations. What it did was state what the owner's position would be if a satisfactory resolution could not be achieved.
Which one would think was perfectly appropriate in the context of parties negotiating?
Well, yes. I mean, the very fact that the appeal panel took a different view does indicate, though, how careful you have to be
Definitely.
in writing letters like this. Now, lawyers would say this, wouldn't they? But suspending the work, for a builder to suspend the works is a very, very big step and shouldn't be taken at all lightly, and similarly with terminating a contract. But His Honour Justice McDougall said what the owners were stating that they were legally entitled to terminate the contract, and that was simply a statement of fact. But as he pointed out, they didn't. There's I suppose, a fairly fine distinction between saying what you're entitled to do and saying you propose to do it and doing it. But that was really, that's an important distinction, and it was a point which it was only fair in context for the owners to make, because it's obviously better to say what you propose to do to give the other side an opportunity to respond than simply do it and leave the other side faced with a fait accompli, which they couldn't do anything about.
An abundance of caution measure, or
Well,
one last chance.
That was how we characterised it. He put it this way: a statement by one contracting party that it has an existing right against the other to terminate the contract is not of itself a statement that the first party does not intend to perform the contract or intends to perform it only in a manner substantially or inconsistent with its terms. And it was also regarded as important that it was accompanied by a statement seeking a resumption of negotiations so that the contract could be performed. But interestingly, as I argued it, we would win either way, because what I said was the unlawful suspension of the contract was repudiatory. Now, that doesn't mean that it was an anticipatory breach. It wasn't somebody saying that they're not going to perform the contract. That it was an actual breach of an essential term of the contract, which would allow another party to terminate the contract. If you remember that line of cases.
Well, in that regard, it's sort of fairly straightforward in that the contract's for building works, the builder stops the works.
That was how we characterised it. The fundamental obligation of the builder in a building case is to carry out the works. If it stops, it's in breach. Now, obviously, if it stops because it's raining or because it's the weekend, but if it's simply down his tools and walks off site, that is a failure to carry out a fundamental obligation under the contract.
So that's a fundamental breach.
Was, as it were, a hedge to my argument. Even if the letter was repudiatory, it would take effect as an acceptance of the builder's breach of an essential term.
Yeah. Even if the letter did repudiate, they were perfectly within their rights to repudiate.
That's
given
right,
the conduct of the builder.
Not repudiate, to accept.
Oh, I'm sorry, to accept the builder's repudiation.
That was how it would properly be characterised. So one way or the other, we argued that the owner was entitled to bring the contract to an end. So that was sufficient to dispose of the case, but there was one final argument I ran, which did not was not successful and was wrong, as it was found by the court, and was overstating the law, and that was based on a paragraph from a well-known decision of the Court of Appeal called DTR Nominees and Mona Homes Proprietary Limited, which is 1978 138 CLR 423. Their Honours in that case said, a party in order to be entitled to rescind for anticipatory breach must at the time of rescission himself be willing to perform the contract on its proper interpretation. Otherwise he is not an innocent party, and the common description of a party entitled to rescind, an innocent party, the common description of a party entitled to rescind for anticipatory breach, and indeed could profit from his misinterpretation of the contract, as the appellant seeks to do in this case. So that was DTR and Mona Homes. it does not stand, as the Court of Appeal emphasised, for the broader proposition that a party who is itself in breach of contract cannot accept the other side's repudiation. It does stand for the proposition that a party who itself is in breach of contract cannot accept the other side's repudiation when the party purporting to accept the repudiation is in breach and that breach has caused or provoked the breach which which it's purporting to accept as ending the contract, if you follow me.
So there must be a causal connection.
There must be a precise...
To use a sort of language of tort.
There must be a causal connection. Yes, that's right. So on that aspect of the case, I was unsuccessful, and I suppose deservedly so. So that was the case. It was obviously a considerable relief to my clients, the homeowners, that after a long time their position was vindicated. And it was also a vindication of the solicitor who'd written letters on behalf of the homeowners, letters which I thought were always courteous and accommodating and sensible, and which at one stage had been characterised by the panel as, in fact, certainly inadvertently, putting the owners in a very bad position.
In that it was taken of evidence and intention not to continue with the contract, where practically speaking, all the owners had to do under the contract was wait for the builder to remedy his breach. Yes. I would have thought.
Yes, that's right.
There's nothing further for them to do.
That's right.
So Tom, having been in this case, firstly before the tribunal, then before the appeal panel, and then finally in the Court of Appeal, what do you think practitioners can take from this decision?
I think three things really. Firstly, it's useful guidance as to what's a question of law.
Always a tricky question.
Always a difficult question. As His Honour Justice McDougall said, there is no bright line, but practitioners, what they really have to do is have to show that either there was no evidence or the evidence that there was did not, as it were, rationally support the finding made.
It's a fairly high test, or very difficult test.
Yes, it is a high test. If you're acting for a builder, this sort of case would only arise in relation, I think, to domestic building contracts, because claims for payment which aren't domestic building contracts are normally dealt with by the Building and Construction Industry Security Payment Act. If you're a practitioner and it's a it's not a residential building contract, you'd simply put in a payment claim. But if the builder hasn't been paid, the power to suspend should be exercised with great caution. And one of the difficulties I think faced by builders, and it's a genuine difficulty, is that an owner might well say he's not going to pay for some original reasons stated. He's had a falling out, or he doesn't like the colour of the laundry. And then when the matter when people draw swords and start fighting, the owner's solicitor may find a whole bunch of other reasons which nobody had in mind for the payment claim not being made. And the builder can find that although he thought, from his point of view, the position was quite simple. He put in his bill it wasn't paid so he could suspend work. Suddenly all these things he'd never thought of put him in a position where he's actually breached in a very grave way the contract. If I was a builder's lawyer right at the early stage, I would be tempted to put something in the contract saying that if you refuse to pay my claim, you're confined to the reasons, in a show cause sort of procedure you've given for not paying them, and you can't come up with a whole bunch later on, because that can actually work injustice on builders. Another lesson for builders is put your payment claims in proper form. If the payment claim has prescriptions about payment, how the payment claim should be put forward, then observe them. Don't claim payment for works which haven't been completed.
Always a good idea.
It's tempting though, because particularly when they've ordered material and they've
incurred those costs. Things like windows, and they've actually paid for the windows. They want to get paid for them for cash flow purposes. The disputed invoice in this case was quite sparse. It's extracted in the judgment.
It's extracted in the judgment.
Waterproofing 5,000.
But it's not uncommon to see that
No, that's true.
that sort of thing. Builders like to build. They don't like to
spend time crafting invoices.
That's quite right. From the owner's perspective, there aren't that many lessons to be drawn, except for be very careful the way you draft your letters. The solicitor in this particular case wrote letters with great care, and even then there was a prospect of an adverse outcome. So you really, when it comes to a situation where you're ending a contract, the letters that are written are of the first importance and should always be written with a view to the fact they may be read out in court and to determine what the intentions of the parties are. It's really a matter for specialists. Luckily, the solicitors in this matter were specialists.
So practitioners really have to be meticulous in drafting letters going to breach.
Yes, they could probably do it with a copy of His Honour Justice McDougall's judgment in this case actually in front of them. So that will be a guide to them as to how you write a letter so as not to inadvertently have the other side accusing you of repudiating the contract.
Court of Appeal approved.
Yes, Court of Appeal approved. That's right.
Well, Tom, thank you so much for the conversation today, particularly as you've been in the litigation at every stage. It's been extremely valuable to hear your insights.
Thank you very much, Anita.